Oyez, oyez, the United States Supreme Court is now in session. All who have business before this court, please stand and be heard. We are here on one case today, William Denault, petitioner versus the State of Olympus, respondent. Counsel for the petitioner, are you ready to proceed?
We are, Your Honor.
Counsel for the respondent, are you ready to proceed?
We are, Your Honor.
All right, Mr. Roberts, lectern is yours.
And before I proceed, may I ask who's serving as our Chief Justice?
Yes, I am.
Mr. Chief Justice, we respectfully request 3 minutes for rebuttal.
3 minutes. Granted.
Mr. Chief Justice, Your Honors, may it please the Court. My name is Shane Roberts, and my co-counsel's name is Claire Downey. Together, we represent the petitioner, Mr. William Denault, on his Fifth and Eighth Amendment claims, respectively. I'll be addressing his Fifth Amendment claim. We ask this court to overturn the ruling of Olympus's Supreme Court and find that Olympus's use of the functional brain mapping exam facially violates the Fifth Amendment's protection against self-incrimination because it forces its test subjects to become the deluded instruments of their own conviction. We have two arguments.
Did you say deluded or diluted?
Deluded, Your Honor.
In what sense?
Deluded in the sense that the nature of the functional brain mapping exam doesn't give its test subjects all the information they need to know. Namely, the fact that it extracts memories from their mind that are later used at trial to not only incriminate, but convict them. And the language of...
I thought the record indicated that he was informed, your client was informed of the nature of what was going to take place. I understand he didn't speak at all, but nonetheless he was not going in there unwittingly.
Well, Mr. Chief Justice, that gets back at the point of delusion, because on page 5, paragraph 1 of the record, the technicians told our client that it was quote-unquote purely procedural, and that it was not going to require any...
He also told them that the person, your client, was informed that they were working directly with the police.
That's true, Your Honor, but they didn't tell him...
We're really talking semantics, are we not?
No, Your Honor, we're not talking semantics because Mr. Denault did not know that this test was capable of going into his own mind and extracting his memories that could later be used against him at trial.
But isn't this a facial challenge on the Fifth Amendment issue?
It is, Your
So if your core contention is that your client was not informed of the full nature of the test, how does that support a facial challenge? It seems to me that if they simply told future suspects exactly what the test was designed to do, that would cure any defects.
Well, Your Honor, that's the main argument that I'm wishing to raise today. Every single time the functional brain mapping exam is used by the State of Olympus in the context of an investigation, the testimony that exam elicits is testimonial, it's compelled, and it's incriminating.
Let's talk about Weber. Can you explain why the plethysmograph in Weber would be unconstitutional? It was not ruled based on that, but let's say that it was. Why would that be unconstitutional?
Well, Justice Breezen ruled, in his opinion in the Ninth Circuit's decision in Weber, that the penile plethysmograph test didn't only measure physical responses, but it also got at the mind of Mr. Weber. So, if Mr. Weber had raised a Fifth Amendment claim or a Fourth Amendment claim or something of that nature, which he didn't pursuant to footnote 14 of Weber, then this court would have ruled in that instance that it would have violated his right to against self-incrimination.
Can you briefly just outline the statutory challenge that he raised?
Yes, Your Honor. It has its origins in Title 18 of the U.S. Code, Section 5385, I believe, Section D2 specifically, and it's in footnote 14 of Weber. It's a statutory challenge in which Mr. Weber contended that the state that made him take that penile plethysmograph had no rational justification for doing so as part of his sex offender outpatient treatment. And that's why the case in Weber isn't necessarily dispositive today, because it was dealing with a statutory challenge, not a constitutional challenge. This court's ruling was clear in Pennsylvania versus...
You're saying in terms of the dichotomy between the two, yours is a facial challenge that you're dealing with here, as opposed to, in that case, it was as applied, the statute as applied. I think that is the technical distinction, is it not?
That's the technical distinction, Mr. Chief Justice.
Thank you.
The test facially violates the Fifth Amendment's protection against self-incrimination because the Fifth Amendment was created in this word's own language in Pennsylvania versus Muniz to spare individuals accused of criminal offenses from having to reveal directly or even indirectly their knowledge of facts linking them to the offense. Page 2, paragraph...
Two questions about Muniz. First, Mr. Muniz was given sobriety tests in, I believe it was footnote 3 of the case. Those test results were admitted over his objection. Why were his admissions during those sobriety tests admissible?
Well, Your Honor, pursuant to footnote 3 of Muniz, it was because he wasn't in custody. And that's why those tests were allowed and not suppressed at trial.
Now, subsequently, there was a breathalyzer test administered at the police station, and Mr. Muniz ultimately refused to take the test. Why were his admissions during the officer's questioning of him admissible then?
Your Honor, are you getting at whether his admissions...
Let me ask it again. I'm not talking about the 6th birthday question. I'm talking about later when the officer read from a script and asked him if he would submit to the breathalyzer test, and he said no, and then made incriminating remarks.
Your Honor, it's because the officer in that question didn't state anything that would give rise to at least even an inference of something that is incriminating. And in Rhode Island versus Ennis...
It is incriminating. He incriminated himself, certainly.
That's correct, Your Honor, but nothing that the police officer did gave rise to the incrimination. And this court, it looked at the issue of incrimination in Rhode Island versus Ennis, where it looked at two different situations in which the Fifth Amendment can apply. Direct questioning...
To be more direct, he did not interrogate him.
That's correct. He didn't interrogate him, Mr. Muniz, and that's why his responses were not protected by the Fifth Amendment, because the police did nothing to give rise to that response.
Which of the three elements would be failed then because he was not interrogated?
Compulsion, Your Honor. And that strikes at the heart of Justice Brennan's decision in Schmerber versus California, where Justice Brennan, delivering the lead opinion for the court, stated pretty plainly that whenever an individual is subjected to a test that will determine the guilt or innocence of that person on the basis of their physiological responses, whether willed or not, invokes the spirit and the history of the Fifth Amendment.
So it invokes the spirit. I'm hearing two kind of fuzzy weasel words there. First of all, to invoke an amendment's protections is not the same as to violate those protections. And secondly, the spirit of the amendment is not the same as its text and embodiment. So could you explain to me then why we should hold that dictum to be dispositive in this case?
Well, Your Honor, that dictum definitely gets us to the point where this court needs to at least apply the Fifth Amendment. And then it violates the Fifth Amendment because of this court's precedent in Hibble versus the 6th Judicial District of Nevada, as cited in the 10th Circuit Court's decision in United States versus Von Baron, where this court stated pretty clearly that whenever communication is testimonial, compelled, and incriminating, it violates the Fifth Amendment.
I'm failing to see how this is testimonial. He didn't say anything, they didn't really ask him any questions, they just showed him pictures, and if you're saying that it's testimonial just because it asserts some sort of notion, a breathalyzer test asserts that there's alcohol in your system, a blood test could assert substances in your system, so what about it is testimonial?
Your Honor, it's testimonial in the sense that on page 2, paragraph 2 of the record, it elicits memories from its test subjects. In Schmerber versus California, the court ruled that the blood test was physical. No memories were involved. In United States versus Dionysia, they looked at a voice exemplar. No memories were involved.
Does it elicit memories, or does it merely test for the presence of memories?
It tests for the presence of memories, Your Honor, that the prosecution team in Olympus then in turn used at trial to incriminate and convict.
Well, we're not arguing whether it's incriminating. I mean, I think that's fairly clear. The question is it actually eliciting testimony?
Yes, Your Honor, it is eliciting testimony because in the case of Kyler versus the United States, the government used a technology not widely available to the public to get information that could have previously only been obtained through a physical search and seizure.
And that was struck down because they didn't have a warrant.
That's correct, Your Honor. I see that my time is about to expire, Mr. Chief Justice. Can I respond to the honor to your left?
As a matter of fact, you can have 3 minutes additional right now.
Thank you, Mr. Chief Justice. Your Honor, to your point in Kylo, the analysis I was drawing from Kylo versus the United States was simply the fact that it was using a form, or rather it was using a technology not widely available to the public and because it elicited evidence that would have previously not been able to been obtained other than through a search and seizure. So we're not applying Fourth Amendment analysis, which would then implicate your issue of the warrant, but the fact that the functional brain mapping exam elicited memories, which prior to its existence would have only been gathered through testimonial communication.
I had just out of my own curiosity, what was your roadmap?
Your Honor, my roadmap was 1, the functional brain mapping exam conducted by the state of Olympus compels Mr. Denolf to disclose information that was both testimonial and incriminating. And secondly, the functional brain mapping exam violates the Fifth Amendment every single time it's used.
Thank you very much.
Thank you, Mr. Chief Justice.
Ms. Downey.
Mr. Chief Justice, Your Honors, may it please the Court. My name is Claire Downey, and I represent the petitioner, Mr. William Denolf, on his Eighth Amendment cruel and unusual punishment claim. Your Honors, both the sentence handed down by Judge Fair in this case and the conditions in which that sentence have been required to serve violate the Eighth Amendment cruel and unusual punishment clause. It's because of this that my co-counsel and I submit 2 arguments on this point. The first is that the term of the sentence handed down by Judge Fair is grossly disproportional and violates the constitutional standards. The second issue examines the conditions in which that sentence was served.
Disproportionate in what way?
Your Honor, this court handed down a tripartite balancing test in Solem v. Helm, which is cited in Harmelin v. Michigan. That test requires this court to evaluate the nature of the crimes committed against other ways similar crimes are treated within the state and the way that the country at large deals with certain issues.
What crime was Mr. Solem, can you go through, and it is discussed in Harmelin briefly, what crimes did Mr. Solem commit?
Your Honor, I'm not aware as to those facts. The Solem v. Helm tripartite test is the appropriate standard to apply in this case because it evaluates proportionality on a case-by-case basis. Something that this court has recognized is foundational to understanding the evolving standards of the Eighth Amendment as cited in Trop v. Dulles.
Do we do proportionality analysis on capital cases?
Yes, Your Honor. In fact, this court has previously done proportionality arguments in Gregg v. Georgia, which is also cited in Harmelin v. Michigan.
That was holding that it couldn't be a capital case, right?
Your Honor, I'm not sure I understand your question.
Gregg was about whether or not they could impose the death penalty.
Yes, Your Honor.
But with regards to cases in which you can impose the death penalty, or at least that's not a certified question here, is there any point in proportionality analysis for sentences beneath that of the death penalty?
There's a twofold response, Your Honor. The first is that this court has not previously done analysis on proportionality in capital cases, but that doesn't necessarily mean that the court would uphold all particular punishments authorized
To
by...
refresh my memory now, did your client not admit that he tortured the victim in that case?
No, Your Honor. My client maintains his innocence. Yes, Your Honor.
Okay, I think you run into a problem
Yes.
with Harmelin.
Yes, Your Honor.
Harmelin dealt with cocaine possession and a life sentence.
Yes, Your Honor.
And this court held that that was not grossly disproportionate.
Yes, Your Honor. That's
Your
correct.
client committed a much more serious offense with a less severe punishment, only 30 years. He will be released someday.
Yes, Your Honor. However, the unique aspect of this case, and the aspect of this case that's brought to trial today, is the issue of solitary confinement, which is grossly disproportional to the crime committed for 2 foundational reasons. The first is the unique method of sentencing in the state of Olympus. Page 7, paragraph 2 of the record indicates that Olympus is the only state that allows judges to specifically sentence individuals to punitive solitary confinement.
Wasn't Michigan the only state that authorized life without parole for cocaine possession?
Yes, Your Honor.
So we said even standing alone, it still was constitutional.
Yes, Your Honor. That was the ruling in Harmelin v. Michigan. However, this is different because of the administrative distinction. The term of punishment itself, the length of 30 years, for example, is not at issue today. Only the method in which those 30 years were handed down, the issue of solitary confinement. The term itself is not the question, but the unique nature of the term in its solitary status.
So the fact that, a punishment which would not otherwise be cruel and unusual can become cruel and unusual if it is imposed at sentencing rather than through administrative penal procedures?
Your Honor, in some circumstances, yes. However, even if this court rejects the issue with Judge Fair's ruling, there is a unique distinction that makes Olympus disproportionate on this level, and that's the term of the sentence itself. The
I
longest,
thought you just said the term wasn't at issue.
Your Honor, the length of solitary confinement. My apologies for misspeaking there. The longest sentence that this court has ever reviewed under a solitary confinement claim is a period of 30 days in Hutto versus.
There's a lot of things we haven't reviewed.
Yes,
That
Your
doesn't mean they're impermissible.
That's true, Your Honor. And the language in Hutto was actually highly skeptical of the length of confinement. Now, the 30 days was kind of judiciously or hesitatingly handed down by this court, and the characterization of the critique of the prison in Arkansas that the Hutto case addressed is pretty clear on that matter.
What
Mr.
were the
Denault-
footnote 3, I think it is, discusses the conditions in Hutto. What were the conditions of the prison?
Your Honor, they were double-selling prisoners, they were not feeding the prisoners, they were convicted to forced labor, and they were also had terms of punitive solitary confinement for up to 30 days.
Just
So-
for clarification, they were feeding them grew, but they were not feeding, they were just insufficient.
Oh, yes, Your Honor, my apologies, I'm misspeaking there.
So you're arguing that because we thought that 30 days was a problem under abominable conditions,
Yes, Your Honor.
therefore we should find that 30 days is a reasonable limitation even in what, aside from the lack of personal contact, would basically be a modern efficiency apartment?
Your Honor, specifically Olympus itself has recognized a 30-day limit, since the record stipulates that Olympus defines solitary confinement as up to 30 days. However,
While we're on that subject,
Yes, Your Honor.
there are 6 types of protected housing, one of which is solitary confinement. What are 2 other types?
2 other types would be mental health rehabilitation, solitary or confinement, as well as restrictive housing for those things that are like involved with gang members, as well as medical health, as well as investigative health. There's a plethora of options for Olympus to confine individuals who pose a threat to the prison body. Mr. Knoll was not one of those
Are you
individuals.
asking the court not to accord any deference to the fact that as a result of the client's mental state, it has been exacerbated very badly because of this? Are you putting any emphasis on that?
Yes, Your Honor. That moves to my second argument, the conditions in which Mr. Denault was forced to serve his sentence. Now, the lower court, the Northern District of California, applied Supreme Court precedent in a case of prison conditions somewhat similar to the one at bar today, and they recognized a number of failings on the part of a lower district court, or rather of a lower prison, and the way that it confined its prisoners.
I have to disagree with you on the
Yes,
word
Your
similar.
Yes, Your Honor.
In Madrid, weren't there instances of prisoners being caged naked outside in the cold?
That's certainly within the purview of what was happening. It was definitely a difficult case for the lower court to review.
My point is just as a whole, the conditions are much different. Like in Hutto,
Yes, Your Honor.
the conditions are certainly different.
Yes,
They're
Your Honor.
closer to the modern conditions that were discussed earlier.
Yes, Your Honor. However, there was one foundational issue in Madrid worth examining here, and that is the court's precedent handed down in Lightfoot versus Walker, which was cited in Madrid, in which this court recognized that medical screenings are necessary for individuals that are going to be incarcerated. Mr. Denault received no such screening, and if he had, it is likely that his prison sentence of
Did he
solitary...
raise any issue of health at sentencing? Because remember, this is not the prison that decided to put him in solitary. This is the judge. So you wouldn't raise it before the prison, you'd raise it before the judge. Did Mr. Denault, in fact, raise any objection based on his mental health before he was sentenced?
Mr. Chief Justice, I see that my time is about to expire. May I briefly respond to the question?
Actually, you have 3 minutes additional.
Yes, Your Honor. 2 points of response, Your Honor. The first is that Mr. Denault did stipulate to his mental stability at the time of trial. That was prior to the 3 years of isolation that he served with little to no human contact and really no medical treatment for his mental instability that's stipulated to in footnote 2 of the record. Additionally, Your Honor, the fact that he was mentally sound at the time of trial does not excuse Poseidon Penitentiary for their indifference to the way that he was treated and their lack of screenings upon examination.
But it's the sentence that you're challenging, not the administration of the penitentiary.
Respectfully not, Your Honor. This court has always examined incarceration claims in context, as this court applied in Helling versus McKinley, as well as in Hutto versus Finney, to mention 2.
In Helling, there were 2 subsequent developments that occurred that lessened the objective risk of harm to Mr. McKinney? What were those two subsequent developments?
Your Honor, I believe that one of them was the imposition of smoking bans within the building.
Thank you very much.
Thank you, Your Honor.
Mr. Shelton.
Just one moment.
Yeah, just give us a second.
Yes, Your Honor.
You all ready? Yeah. Proceed, please.
Mr. Chief Justice, Your Honors, and may it please the Court. My name is Andrew Shelton, and I, along with my co-counsel, Nicole Cordaro, represent the respondent, the State of Olympus. I will be arguing that the functional brain mapping exam conducted on Mr. Denault by the State of Olympus does not violate the self-incrimination clause of the Fifth Amendment, and my co-counsel will be addressing the Eighth Amendment claim.
Why does it not, as an objective review, present the petitioners a terrible paradox in the sense that they either come and take the exam, or if they don't, and particularly in a situation like this where presence at the crime scene would be a very strong argument for guilt, that basically if they, as in this case, he came in and took the test, basically, and then, or conversely, if he did not take it, I assume that fact that he did not take the test, since the doctors were working with the police, that would be reported to the police. So, in a sense, your situation internally presents the petitioner with a paradox, does it not?
Mr. Chief Justice, I would disagree that Mr. Denault was presented with a paradox. We believe that the state informed Mr. Denault he was able to leave at any time within the record, and that Mr. Denault chose not to, and instead chose to cooperate.
That's my point. If he, was presented with that dilemma, he's there with peaceful observing and everything, he says that he knows that the machine is going to do some recording, which probably is going to be inimical to his interests. And if he then either stops or walks away from it, that is going to be reported to the police and would probably be a very adverse thing on the record.
Your Honor, it is correct that that might be reported to the police, but there's no indication that it would be able or permissible for the state to use that against him if he did not take the test.
Why shouldn't we follow Von Baron?
Your Honor, specifically Von Baron is distinguishable because the individual was compelled because he was given a penalty. If he did not answer 3 out of the 4 questions that were incriminating in Von Baron, then he would be removed from the supervised release program and put back into prison. Here, Mr. Denault was not threatened with any penalties and was specifically told that he could leave. So Von Baron is quite distinguishable from this case here today.
How is this case more like Noble than Von Baron?
Your Honor, it's more like Commonwealth versus Noble, because in Commonwealth versus Noble, the individual went from his own will to the testing and signed the contract and agreed to the terms of testing.
But he had to. It was part of his probation, correct?
Yes, it was part of the contract.
While I'm on the subject, what crime did Mr. Noble commit that subjected him to this probation?
I believe it was possession of child pornography or other sexual crimes involving a minor.
That I think you're referring to Weber.
Okay, yes, Your Honor. But specifically, looking to the test laid out by this court that opposing counsel mentioned, an individual piece of evidence must be compelled, testimonial, and incriminating for it to be protected by the Fifth Amendment. Here, we raise 2 arguments for the state. First, that the FBME does not produce testimonial, but rather physical evidence. And second, that
What is the difference?
Your Honor, the difference between testimonial and physical evidence, as this court laid out in Doe versus United States, is that testimonial evidence must communicate a factual assertion or disclose information. The evidence itself must be the one that communicates it. Here, it is not the evidence itself communicating.
However, if the person has taken this test and the reports to the police are that every star on the screen lit up when the room was shown. That would be almost conclusive evidence that he was there.
You're correct, Your Honor, that would be conclusive evidence and was in fact in this case. However, that does not mean it is testimonial. In fact, a breathalyzer can also be conclusive evidence in an individual case, and yet it is still physical evidence. Another example would be a blood test, as in this court's ruling in Schmerber versus California.
Why is it more like a blood test or a breathalyzer than, say, a polygraph or a plethysmograph?
Your Honor, it's more like a blood test because it specifically requires the expert technicians to interpret the data. And in
Doesn't
addition,
a polygraph or a plethysmograph require the same?
Your Honor, it does. However, in the plethysmograph reference in United States versus Weber, that was not actually specifically held to be unconstitutional. Specifically relating to the polygraph, there are distinctions between the physiological responses here.
I'd like to go to Muniz for just a second.
Yes, Your
with
Honor.
the breathalyzer. Mr. Muniz was asked the 6th birthday question, and he said he didn't know, and that the content was used against him. If he had answered the question correctly, would he have been able to make a Fifth Amendment violation claim?
I believe so, Your Honor, because even if the evidence is not actually incriminating, if the officer is asking the question with a reasonable expectation that it would be incriminating, then that is still an incriminatory question by the officer.
But what content would be used that was incriminated? He correctly answered the question. Wasn't the point of the court's opinion that the content was different than what a judge would expect a sober person to say? So if he correctly responded, then it wouldn't be incriminating.
That's correct. Mr. Muniz in that situation would be unlikely to raise a Fifth Amendment claim, but at the same
Sure,
time,
absolutely.
he would be likely to succeed in that claim. But further,
While I'm on the subject, let's talk about Estelle.
yes, Your Honor.
Estelle discussed the psychiatric evaluation and questions.
Yes, Your Honor.
If there was no court order in Estelle, would Mr. Smith have been able to raise a Fifth Amendment violation?
Yes, Your Honor, Mr. Smith would have been able to raise that claim because there would have been inherently compelling influences, which this court held in Rhode Island versus Innis, are present when the state officers are the ones conducting the question.
Let me ask a hypothetical state you back in history. What do you think, in all candor, if the founders of the draft of the Fifth Amendment Constitution, we all know the abuses that they have experienced in Europe in those early years, where the purpose of the Fifth Amendment was not to basically prohibit or coerce people into incriminating themselves. What do you think they would have said if they realized that was a machine that could be brought to bear to show the mental condition of the petitioner?
Your Honor, it's because the spirit of the Fifth Amendment and the history throughout the Fifth Amendment has been to protect individuals from being compelled to testify against themselves, which was specifically originally regarding court cases and actually getting up and testifying, but has been extended further into informal proceedings.
But in the light of the paradox that I saw probably inaccurately to present to you earlier, is not the person faced with the dilemma once they're in the police station and either have to make the decision here to walk away from the test or to take it, and with the premise that the fact that they did not take the test could be reported to the police. Isn't that at least tangentially incriminating?
Your Honor, we do not believe that the dilemma presented is actually a significant penalty against the individual that would be used in court against them. Simply because they do not prefer to take a test would not be incriminating evidence against Mr. Denol.
It's not any more incriminating than any other criminal defendant facing the dilemma of do I incriminate myself or not. There's no penalty for remaining silent, but if I say something, I incriminate myself.
The Massachusetts courts recently had a ruling that prior to the ruling that I'm going to advert to right now, was that if a person refused to take the breathalyzer test on the highway, they would lose their license automatically for a 9-month period. And probably not, but that is the penalty. If they don't take the breathalyzer test, they lose their license automatically. Why is not the spirit of that decision the penalty that comes from not observing the police wishes relevant?
Your Honor, it's because there was no such penalty here. In fact, Mr. Denolf was specifically informed that he was able to leave the facility and was not compelled by the officers. Furthermore, petitioner...
But to answer the Chief Justice's question more directly, couldn't it be that there was no testimonial answer? It's just the blowing into the tube. Would that be more likely?
Yes, Your Honor, that could also be the case. In fact, since this is physical evidence, that is also applicable to that question. But furthermore, petitioner has raised a facial challenge, and to typically succeed in a facial challenge must prove that in all circumstances possible, this evidence would be compelled from the individual by the functional brain mapping exam, which has not been demonstrated by this one specific case of Mr. Denolf. And it's because this is not testimonial in most cases and is in fact physical evidence and is not compelled by the functional brain mapping exam that we would ask this court to affirm.
Thank you.
Thank you, Mr. Shepherd.
Let's go down.
Just one.
Yeah.
May I proceed, Chief Justice?
Please.
Mr. Chief Justice, Your Honors, and may it please the Court. My name is Nicole Cordaro, and today I rise to represent the respondent, the State of Olympus, on the Eighth Amendment claim. Your Honors, the petitioner is a convicted murderer. On March 17th of 2014, he hired a prostitute half his age, tortured her, and then brutally murdered her. It lies firmly within the power of the state to sentence this petitioner to solitary confinement.
And in the late 1990s, Christopher Simmons brutally duct taped and murdered an elderly woman. He still said that the death penalty was not appropriate in Roper.
Your Honor, there are two distinctions between the present case and the case of Roper versus Simmons. The first is that the reason that the court ruled that Roper wasn't able to receive the death penalty was because he was a minor. In this case, Mr. Denolf is not a minor. Additionally, we can see a distinction between these two cases is because Mr. Denolf is not facing the death penalty. Rather, he's facing a lesser sentence of 30 years.
Can you respond to Ms. Downing's argument about gross disproportionality?
Yes, Your Honor, and I would actually respond using the Associate Justice here's question in that capital punishment or crimes that can receive capital punishment have never been ruled to have been disproportionate by this court in the record. Essentially, what we can see in today's record is that this court has never ruled on a disproportionality claim unless the petitioner or the defendant in a specific case was being faced with a capital punishment, in which Mr. Denolf is not being faced with today. Rather, he's being faced with a 30-year punishment in which he can be released. Additionally, we can see that under Mr. Denolf's sentence, he is not even required to serve 30 years of solitary confinement necessarily. In fact, after half of his sentence, 15 years, the warden can then choose to release Mr. Denolf out of solitary confinement and into the general prison population. Now,
So if I sentence someone to 70 years in prison for overtime parking, but I put a mechanism in there that said that the warden could release the inmate into society after 14 days, would that still be constitutional?
Your Honor, it would depend vastly upon the specifics of the case. And in fact, that...
Well, let's do a disproportionality analysis. Why would that be grossly disproportionate or not?
Your Honor, I don't believe using the cases in our record that it could necessarily be determined as disproportional. For example, in the case of Harmelin versus Michigan, this court decided that an offender who possessed 672, I believe, grams of cocaine and then was sentenced with a life sentence for that possession, they argued that this was not disproportional because it was within the state's jurisdiction to decide how prisoners will be sentenced. And that actually is my second point that I would like to bring today. The first point, however, is that petitioner has failed to show that Mr. Denolf's sentence violates evolving standards of decency. And the second claim that respondent would put forth is that the state should be granted broad deference in administering its own justice system. Now, on
Let's see, I have a question about the deference.
Yes, Your Honor.
You're correct, and in Rhodes, footnotes 14, 15, and 16 talk about deference, but there they talk about it as to security, gang members, and the warden. We have none of those three things here. There's no security risk, and a judge made the decision. This court is uniquely qualified to rule on questions of a judge's decision.
Yes, Your Honor, and because it was a judge's decision, I think that this court should uniquely be looking at the case of Ewing versus California over the case of Rose versus Chapman in making a state deference claim, in which this court decided that there is not one constitutionally mandated penological justification for a sentence.
However, you have indicated a few moments ago an awareness of the evolving standards of decency in the country. I'm sure you are aware now that that evolving standard is being keynoted by a kind of humanitarian view of the way that prisoners and crimes should be conducted. So if we were to comport with the national trend towards evolving standards, that would be arguably cutting against your argument.
Your Honor, I would respectfully disagree, and I would assert that this court should look at the case of Roper versus Simmons in making this determination of what an evolving standard is. In that case, this court...
On the front page of the New York Times this morning, which I guess is outside the record, adverts to the situation in New York, where a number of people who were convicted of serious crimes because of our recent Supreme Court decision, which indicated that the connection between taking gifts and receiving gifts did not constitute sufficient evidence. And so those three convictions were reversed. So, I mean, to me, that's quite a significant standard in terms of evolving standard.
Your
I
Honor,
realize that wasn't in the record. I didn't mean to surprise you with that, but it struck me.
Your Honor, the respondent would urge this court to look rather than at subjective standards of broad ideals that this society would uphold, but rather at objective standards, which is what this court held in the case of Roper versus Simmons. One such objective standard being the actions of other legislatures. And as we can see in the record, in fact, 40 states and the federal government all institute some sort of solitary confinement.
Can you comment on the international review that was discussed in Roper?
Your Honor, I'm not entirely... I do believe in Roper they were discussing that internationally there are no Western countries that actually subject individuals that are below the age of 18 to capital punishment.
I'd like to pull you back for 1 second to when you said that they could, after 15 years, he could be taken out of solitary confinement. I'd say that 15 years is still an incredibly long time, and it's much longer than, I believe 30 days is the longest we've ever upheld someone being held in solitary confinement for. Is the difference between 15 years and 30 years really that much?
Your Honor, in the case of Pepperling versus Chris, as cited within the case of Madrid versus Gomez, a lower court actually determined a solitary confinement sentence of 12 years to be constitutional. So courts in this country have examined solitary confinement periods that are longer than...
Do we know the age of the inmate in Pepperdine?
No, Your Honor, I'm not aware of the age.
That's all. How old is Mr. Denolf?
I believe Mr. Denolf is 45 years old, but I may be incorrect.
Let's say he's 50. He is 55.
All right, thank you, Your Honor.
All right, so even 15 years would be 70. That may very well be the rest of his life.
Yes, Your Honor.
Does that matter, his age?
Your Honor, in the case of Hutto versus Finney, this court ruled that the length of a sentence, which would therefore relate to the age of the prisoner, if that would be a life sentence or not, is not the sole determination. Rather, it's a conglomeration of factors that must be taken into account. Now, Your Honors, if we look at Mr. Denolf's sentence specifically, we can see that this court has always held an extremely high standard of finding a fact in order to determine whether a medical or a mental necessity is actually being violated under the Eighth Amendment. And in fact, in every case on our record, this court has never ruled in favor of a violation unless it was a flagrant and unwanted, unnecessary infliction of pain, which is the standard set in the case of Rose versus Chapman.
You may be right, but it seems that this case kind of is a conflagration of Helling and Madrid. No, the conditions are not as bad as Madrid, but we have a risk, in Helling of serious mental health. So shouldn't we step in and stop it before it happens like it did in Madrid?
Your Honor, I do agree, and the state would agree, that mental health is a serious consideration. However, what petitioner must prove to you is that, one, it's a serious risk specifically to Mr. Denolf, and that risk is serious due to sufficient finding of fact and prove that to you, but additionally that there is culpability on the side of the state. Now, if we look at the case of Madrid versus Gomez, we can see marked differences between that case and the case at present. The first difference is that Madrid is actually a lower court case. It was-
While I'm on the subject of Madrid,
Yes, Your Honor.
what are fetal restraints?
Your Honor, I believe fetal restraints were the restraints that they put certain prisoners in to be held in certain body positions, such as the fetal position.
What is the code of silence?
The code of silence was a code throughout the prisoners that they wouldn't, to put it in legal terms, incriminate other prisoners, or basically that they
Prisoners or employees?
I believe it was prisoners, but I may be incorrect on that.
From a societal point of view, what do you think is the most significant advantage to society for these protracted periods of solitary confinement?
Your Honor, in the case of Ewing versus California, this court discussed several different penological theories that can be put forward for a sentence to be constitutional. And I believe that there are a few that are applicable in this case. One being that of incapacitation. The sentence of solitary confinement incapacitates Mr. Denolf from being able to commit similar crimes among the general prison population.
I have an issue with deterrence.
All right, Your Honor.
Two problems. First, the record indicates that inmates reoffend in 12 months versus 27 months for general population. And second, footnote 204 of Madrid discusses it was inconclusive as to the effectiveness of solitary confinement. So I'm questioning whether the deterrence rationale is effective.
Mr. Chief Justice, I see that my time has expired. May I answer the Associate Justice's
You also
question?
have 3 minutes.
Thank you, Your Honor. Now, to answer your question, Associate Justice, I would argue that the state is not putting forth necessarily a deterrence claim, but rather a claim of incapacitation, which is a sufficient penological justification under the case of Ewing versus California.
Why must he be segregated in solitary versus incapacitation from the citizens? I believe you've already admitted this is not a security case of a gang member, so why wouldn't general population serve the incapacitation rationale?
Your Honor, in the state of Olympus, and according to the record, the majority of individuals who torture their victims before murdering them are sentenced to solitary confinement.
At the risk of sounding too informal, that sounds very retribution-y to me and not enough incapacitation to me.
Your Honor, the state does also put forth the retribution standard as a penological justification. It can be a combination of standards, retribution being one of them, but incapacitation, in the case that Mr. Denolf, does subject other individuals within the general prison population to the same crimes that he committed against Ms. Andrea Somerville.
Well, thank you very much.
Thank you, Chief Justice and Associate Justices.
Thank you, Mr. President.
Brief rebuttal.
Are you each doing a rebuttal? Or are you handing
Yes, Your Honor.
2 minutes?
Yes, Your Honor. May it please the court.
Yes, please.
Your Honors, Mr. Denolf was accused of a horrific crime. He was then convicted through the use of evidence that never should have been admissible in court. He was sentenced to a grossly disproportionate term that was out of line with any legal standard that this court has ever reviewed. And then he was forced to serve that sentence in conditions that highlight the gross negligence on the part of the state to attend to the medical needs of those under their care. I have several points of rebuttal, the first of which is that the FBME test measures physiological responses that the court and the state use to determine guilt or innocence. This court recognized in Schmerber versus California that those physiological responses used to determine guilt or innocence certainly implicate the Fifth Amendment. And in this case, the FBME meets all 3 of the standards found in Hibble versus the 6th Judicial District of Nevada, as cited in the decision in Schmerber. Additionally, Your Honor...
Wasn't Von Barron?
Oh, Von Barron, Your Honor. Yes, I misspoke. Additionally, Your Honor, this court's precedent set in Councilman versus Hitchcock, as cited in Schmerber, indicates that the Fifth Amendment is as broad as the mischief against which it seeks to protect individuals. The mischief of the state is obvious in this
What
case.
specific mischief does it seek to prevent?
Your Honor, the mischief of coerced testimony on the part of those individuals against themselves. The issue of self-incrimination, which is clearly implicated by the fact that Mr. Denolf was convicted using very little evidence aside from the FBME at trial.
Can you marshal the evidence against him besides the FBME?
Your Honor, I believe the only other evidence entered at trial was the testimony of the 2 detectives that actually identified Mr. Denolf as being present at the Sleep Suites Hotel on the night of Mrs. Somerville's death.
I'm having a little trouble
Yes,
with your phrasing when you said that the prison unit had gross negligence. They fed him properly. They was allowed to contact his lawyer. He could have asked for medical attention. What about this was grossly negligent?
Your Honor, specifically the gross negligence falls in the area of mental health care. As the facts of the record indicate, Mr. Denolf was not actually treated for his mental illness through the use of any of the 3 psychiatrists on call. He also was never screened for mental health, something that this court recognized was foundational in Lightfoot versus Walker, a Supreme Court case as cited in Madrid versus Gomez. Now, opposing counsel has argued that this court ought to grant deference, but that deference is not blind. The court is examining a case today that involves a penalty 365 times higher than the 30-day penalty that this court so hesitatingly upheld in Puto versus Finney. Your Honor,
Just a brief
yes.
fact question. Why did Mr. Denolf's defense was he was only going to have sex with Ms. Somerville, but he did not? Why wasn't the transaction complete?
Your Honor, Mr. Chief Justice, I see that my time has expired. May I respond briefly to your...
Sure.
Thank you, Your Honor.
Briefly.
Yes, Your Honor. The facts indicate that Mr. Denolf received a call from his wife who told him to come home, and I believe he left very quickly at that point. Thank you.
Thank you very much.